Hello, everyone, and welcome to the second event in our PDPA Preparedness series on how the PDPA impacts human resources, produced jointly by our HR and legal committees. This event is the second in a series of 5 episodes, each focused on a particular aspect of implementation. Before we start, I'd just like to take care of a few housekeeping details. After our speakers finish their presentations, we'll have some time for Q&A. So please do submit your questions through the Q&A feature, which you can see at the bottom of the screen. Now, time permitting, our moderator will call on you for questions and invite you to unmute and ask your questions directly of the speakers. Please do make sure that you're named correctly with your name and business so that our moderator is able to call on you. Finally, this event will be recorded and shared with our members along with presentation slides in the members section of the AMCHAM website. Now, without further ado, I would like to pass this to Doug Mansell, our legal committee co-chair, to introduce our speakers. Doug?
Okay, I should be unmuted. Thank you very much, Khun Sarawan. As Khun Sarawan mentioned, I'm a co-chair of the legal committee. I'm also the managing partner of Legal Analytics. I'll be introducing our speakers today. I think our first speaker will be, well, there's 2 speakers. Khun Marion will be speaking. Marion is the regional head of labor relations at DFDL, which is a regional law firm in Southeast Asia. She has international experience. She's French qualified. She's practiced in Dubai and France, and I think in Ho Chi Minh City. And she has experience with the PDPA and labor issues, cross-border labor issues. So I believe she'll be going first, although it's going to be a Q&A format. So it may not be entirely accurate. And then next, Ed will go. Ed Attanasio is the Senior Vice President of Fabrinet, which is a IT company here. He's been here a bit over 2 years. And before that, he was at Salmonia for about 10 years. And I know him from that time because he used to come over here periodically to Thailand because they had a factory here. Ed has a law degree from Stanford, an undergraduate degree in labor relations from Cornell. Both of the speakers are highly qualified and I'm sure we'll do an excellent job addressing these issues. We have a Q&A format, so I will end here and let the substance of the event start now. Hello?
So, sorry, should I go first?
Sure. I think there's going to be Q&A. So,
well,
Sean?
sorry, I think, yeah, no. It's Marion. What will happen first is Marion will present.
Oh, okay, she'll do her presentation. Okay, that's fine.
Yes, I mean, can somebody share the screen so that the audience can see the slides? Great, thank you so much. Okay, next slide, please. So maybe before we go deeper into the subject, into the topic today, maybe just a quick reminder on the scope of application of the PDPA, because I think it is important that you understand whether the PDPA applies to you, applies to your company or not. So there are actually 2 situations in which the PDPA will directly apply. First, when the personal data is collected, used, or disclosed by any data controller or data processor established in Thailand, regardless of whether such a collection, use, transfer, or disclosure takes place outside Thailand. And second, where the personal data is collected from individuals residing in Thailand, So in the case, of course, the data controller or data processor engages in activities of offering products or services to such individuals, but bearing in mind that it will be regardless whether there is any payment made by such individuals. So these are the two cases in which, you know, the PDPA will directly apply, and where employers need to abide by the rules of the PDPA. And second, also quick reminder about what actually constitutes a personal data. So constitute a personal data, any information relating to an individual which enables the identification of the individual, whether directly or indirectly. So this will, of course, cover name, age, social security numbers, bank details, and etc. It should, however, be noted that the PDPA does not include the specific personal data of a deceased person. So only the alive person will be concerned. Next slide, please. So employees' consent. So those who are a little bit familiar with the provisions of the PDPA will know that it's, I would say, the crux and the core of the PDPA structure. Because the general principle is that in order to collect and process personal data, you need to rely on a lawful basis as provided by the PDPA. So the PDPA will provide a general rule, which is, okay, if as an employer, you want to process your employees' data, you need to obtain the employee's consent. There are, of course, requirements that applies to such consent. The consent must be explicit, meaning that you need to have the consent of your employee in a written statement or via electronic means, but implicit consent will not be received, and it will not be valid. It is important also that the request for consent is clearly distinct from other terms and conditions. And also the consent should be informed and freely given, meaning that the information provided to the employee at the same time of the request must be understandable in a clear language, shall not be deceptive or misleading. Likewise, the consent of processing, I would say, unnecessary or irrelevant data should not be a condition to enter into a contract. So this is the general rule. You need to get your employee's consent. The PDPA, however, provides several exemptions that, as an employer, you can rely when you need to collect, you know, the data of your employees. And of course, these are not listed in the presentation today, and especially in the slide, because there are a series of exceptions, and they are not all relevant for the HR topic. But two that are worth mentioning is, first, legal obligations when the collection or processing of data is required by applicable laws and regulations. And second is the contract, where processing the personal data is required as per the terms of the contract, to whom, of course, the data subject, the employee, is party. Next slide, please. Information upon hiring. So why is it slide called information upon hiring? This is because most of the time the personal data will be collected when the employee will be hired, because for the purpose of, you know, putting in place, you know, the tax declarations and payment of salaries and just recording the employees in the companies file, then an employer will need to obtain specific information. So it is important to note that goes along with the requirement to obtain the employee's consent, sufficient information that need to be provided to the employee. So this is the responsibility of the employer to provide information as to the type of data collected, whether, you know, the data is sensitive or not, the purpose of collection or disclosure or processing, this is a very important information to provide, because actually the extent, the admissible extent in which the employer will be able to process and use or whatever the personal data will be limited by the purpose that has been notified to the employee. It is also important and necessary actually to provide information to the employee as to whether it is necessary for the employee to provide the personal data and the consequences in the event that the employee refuses. So here it will be, it means that the employer must provide the legal basis. So whether it is, so the data are required for compliance with applicable law, or whether it is to ensure performance of a contract to which the data subject is a party. Also the retention period, meaning that the PDPA provides that the personal data may be retained for a limited period of time. So this is also important to notify in the information that you provide to the employee. Noting that the PDPA does not really define the concept of retention period. One article says that personal data must be kept no longer than necessary for the purpose for which the data is processed, but there is no clear definition as to the number of years, of months of such retention period. With this in mind, what we recommend is look at, and at least when the data is collected and processed to comply with applicable laws, look at what such a law provides. For instance, under Thai law, so some of you may be familiar with the obligation for employers having more than 10 employees. They have to implement and to have an employee register, which must be maintained for the duration of employment and for a period of at least 2 years after the termination of employment. So those information provided in the employee register will then be able to be retained for a 2 years period after termination of employment. This will be in our view because there is a lack of guidelines from the Personal Data Protection Committee on that. But in our view, 2 years should be enough and necessary for the data to be retained. Still on the information to provide to the employees, in terms of disclosure of personal data, the type of person or entities, organization to whom or which the personal data may be disclosed to. Also information as to the data controller obligation, if it's the companies and the contact details of the person handling requests and information as to the data processing activities. And finally, the data subjects rights that we will cover in the next slide. So next slide, please. Thank you. Employees' rights. So there are a lot of employees' rights enshrined under the PDPA. So the first one is consent withdrawal. Sorry, apologies for the accent. So such a withdrawal must be easy as giving consent. Sorry, this is provided in the PDPA. And also there is the obligation when the employee asks for having his consent withdrawal, that the controller, if there is a potential risk on the employee's right of situation, that the data controller, informs the employee about such a risk. Second is accessibility. So the employee, so data subject, but here we are talking about employees. So the employee has the right to request access and obtain copy of his or her personal data. Third, data portability, meaning the right to receive or transfer his or her personal data to third parties. Fourth, the objection, the right to object to the collection, use, or disclosure of personal data, and this can be requested at any time of the data processing. The right also to be forgotten, the right to request the erasure, destruction, or anonymization of personal data. suspension, so the right to request the suspension of the use of personal data, rectification, the right to update, complete or adjust personal data, and finally, of course, the right to complaint, meaning that the employee has the right to file a claim against the data controller or data processor in the event of breach of the PDPA or unallowed disclosure of data. Next slide, please. Transfer of personal data. So this is another important aspect of the introduced, by the PDPA. For those who are familiar with other sources of data protection, such as the GDPR, in Europe, it's quite similar. So the PDPA prescribes that in the event that the employer wishes to transfer the employee's data to a foreign country outside Thailand, the employer, as a data controller, must ensure that the foreign country has an adequate level of data protection standard. So of course, there is currently a lack of clarification as to what constitutes an adequate level of data protection standard. In our view, it is the countries that allow in place the data protection law with principles similar to the PDPA. And also the employer must ensure that the foreign country complies with the rule for the protection of personal data, which will be further prescribed by the Personal Data Protection Committee. So we are still waiting for guidance on that. So these are the general, this is the general principle. There is exemptions, meaning situations in which such obligation will not be required. So I will probably, I think I will only refer to the three first exemptions. So where the transfer comply with the law. So in such a case, you don't have to comply with the requirements I just discussed. Also, where the transfer is based on the employee's consent, but of course, employees' consent will go along with prior notification as to the foreign country's potential inadequate personal data protection standards. So the employee must be notified, and following which he or she can provide his or her consent. And finally, where the transfer is necessary for the performance of a contract to which the employee is a party, but it is important to note that we don't know what will be the practical interpretation of this provision, whether it is merely possible to just rely upon, for instance, on an employment contract. It remains to be seen. In our view, it is always recommended to rely on the employee's consent to limit the risk of being in breach with the PDPA. And that's it for myself for now.
Okay. Doug, you want me to go?
Yes, please.
I guess
Go
that's a yes.
Please go.
Yeah, as Doug said, my name is Ed Attanasio, and I'm head of HR, worldwide HR for Fabrinet Corporation. I think Doug called it Fabrinet. That would be the French pronunciation of the company. But since we're headquartered in Thailand, I should explain, just give you a little background. First of all, you'll notice my slides are pretty whitewashed, and that's because I intentionally left Fabrinet's name out of this and anyone else's, because the views I express here are my own, and I want to make that clear. As Doug also mentioned, well, we are I consider us, even though we're headquartered here, an American corporation because we are traded on the New York Exchange, and consequently most of our investors are American, and although they trade through the New York Exchange, they could be from anywhere. And most of our customers are American, although by no means exclusively American. We have plenty of Asian and European customers as well. And my prior employer was headquartered in California, whereas Doug mentioned I'm a member of the state bar, but it was otherwise pretty much in the same business. Now, I come at the PDPA from the saying that you may know, where they say, if you're not paying for the product, you are the product. And that's where the PDPA really has its genesis. And I think it's important to understand that when you realize what its application is to HR. The PDPA and other laws like it are really meant to temper or control the trafficking in really privacy, or what's called private information of individuals, because that's what companies like Facebook, Google, Apple, etc., that's what their business really is. It's trafficking in private data of people. They sell, yeah, they're selling advertising space, but it's very targeted, and this private data is used to target it. And the question for governments is who should control this? Who should control how private data is used? And that's where the PDPAs come in, and they certainly have applicability to HR, because I haven't mentioned this, but my company is primarily, well, the world I divide into merchants and consumers, and my company is primarily a merchant to merchant company. That is, we sell goods and we sell them to people who sell goods. Some sell it to other companies, some sell it to individuals. The point being that the people we sell to are not really giving us a lot of private data. We don't deal in private data. Merchants, because they can only act through natural persons, of course, have some private data. Like when a salesperson gives you their business card, that's private information, and you have to deal with it appropriately. So even in that context, you need a policy. But primarily our focus on private data has to do with our employees, because employees are natural persons, and so it comes in HR, not in terms of our consumers. And as I say that is because, you know, this law is primarily directed and meant to control the trafficking in data. And historically, you know, HR departments haven't, or really shouldn't, be trafficking in the private data of their employees. So in essence, you know, if you've been doing things appropriately, you shouldn't have to change a lot of what you're doing now in order to comply with the PDPA. And the reason I say that is because, at least in the United States and Europe, and I think certainly here, you're supposed to keep the private data of your employees private and use it only for employment purposes and not for any other purposes. The PDPA, however, puts a whole structure around this and requires you to institute certain formalities. That is what I'm going to talk about, what you'll need to do in order to apply the PDPA to the HR function. Basically, employees have the right to request access to their private data, object to its collection and use, and to restrict the use of or compel the destruction of the private data. Now, I don't know who's controlling these slides. Can I get the next one? As I say, the first thing you need, even if you don't deal in private data of consumers, you have to implement and apply an HR policy, or, you know, more likely a general policy that applies to all private data collected by the company, that you know, details the requirements for the collection, the use, and disclosure of what the statute calls personal data or sensitive personal data. Next slide, please. Now, personal data is very broadly defined as any information that relates directly or indirectly to an identified or identifiable person, which can be used to trace or distinguish an individual's identity, whether alone or in combination with other identifying information. Let's say this is very broad, and for employees, it includes just about everything about that individual: their name, their address, their phone number, their passport, not just the passport number, but the contents of the passport, where they've been, driver's license number, date of birth, gender, etc. So it covers, you should assume it just covers everything. Sensitive personal data is just what the name implies. It's personal data that's particularly sensitive. And as a practical matter, that just means you should be particularly sensitive about how you handle this information and make sure it doesn't get used in a way it shouldn't be used, and certainly that it doesn't get disclosed outside the context of what you've told employees you're collecting it for. And I've listed here some examples of sensitive personal data and what distinguishes it from just mere, what I'll call mere personal data. And you see it's information about race, ethnicity, political opinions, religious beliefs, sexual behavior, criminal background, health information, disability, labor union membership, genetic data, etc. So as you can see, it's qualitatively, as the name implies, more sensitive. Now you ask, why would you have this sort of information? Well, I'll tell you, in Thailand, as many of you know, most resumes actually, a person puts their religion on it, which I'd like to say as an American I find unusual, but I don't. I actually found in the US, after decades of people wanting not to be discriminated against on the basis of those things, you start seeing resumes where people talk about all the particular religious and ethnic groups that they belong to, which is, you know, neither here nor there. It's just that it's sensitive personal data and you really can't disclose that. And again, as I say, monetize it or try to monetize it in violation of a Personal Data Protection Act. Other things that you'd have here is criminal background. I mean, criminal background checks ordinarily aren't done for all employees, but certain positions require, like in the finance department or in cases I'm familiar with where we do background checks on warehouse employees and others who are in positions of trust. Another good example would be, say, drivers for your executives. You'd want to do a criminal background check, or your customers, a criminal background check, as well as a Department of Motor Vehicle check. So that's what the data that we're talking about protecting is. And if we can go to the next slide, your policy that you put together and that you govern, that effectively governs how you handle personal data and sensitive personal data, basically has to address what the company collects, how it's collected, and how it's used. So it's, you know, what personal data and sensitive personal data is collected must be described in that policy. What is the intended use of that data? To whom is it disclosed and why? And how is it collected? How is it retained and stored? And how is it used? All that has to be addressed in the policy. And as you can, if you think about it, this is going to be a very detailed policy, even when it's just talking about HR stuff. And then finally, you also have to address in the policy, how can the employee request access to or request that change be made to some of their personal data? For example, if they change their name or if they change religious affiliation or whatever it is. And then finally, the policy should address the law requires the policy to address how can the employee complain if the PDPA is violated. And we go to the next slide, please. I gave here, you know, just again as a practical application, what are applicable human resource documents that would have personal data or sensitive personal data. And, you know, you think about it, you come to the conclusion, it's almost every document used by HR, including applications and resumes, employment contracts, work permits, performance appraisals, payroll documents, medical and dental claims, provident fund and pension records, disability claims, background checks, requests for leave, etc. Just about everything will have personal data on it and will be covered by the policy. So you really have to give some thought as to, you know, what is it we collect? How do we collect it? And how are we going to use this information and address all of that in the policy so that, you know, your employees know what they're giving you, why they're giving it, and how you will, most important, how you will handle it. You can go to the next slide, please. So then what I thought might be most useful for you is then to put together, you know, if you want to address the PDPA in terms of, you know, addressing your HR department, this is sort of a broadly speaking, broadly based to-do list of things that need to be done. And first is to formulate the policy and practices, and your practices should follow the policy based on the company's needs. And that involves going through what it is you do, what it is you collect, how you use it, what you use it for, and where you store it and so forth, and put that into a policy. And in doing that, it's a good thought process because it'll give you clues into where perhaps you're not handling the data as sensitively or as carefully as you should. And then you also need to disclose the intended uses and retention means at collection points. I mean, by this, I mean, it might be a good idea to put in certain collection points that you're collecting the personal data and what it's for example, in a job application, health insurance forms, etc. The next thing you have to do, and as I alluded to before, you should be doing this already, but if you're not, this is a good audit and check. You have to store the information securely to make sure that it can't be misused or otherwise misappropriated. And this would involve, you know, physical cabinets being locked and making sure that whatever, you know, cloud-based storage or server-based storage is secured, that certain databases are only accessible by the people who actually need to use it, you know, and are otherwise secured. I don't want to go into, you know, IT security here, but that's something you need to think about, particularly for personal data. And then employees and third-party service or contractual clauses you'll want to look at. By that, I mean, you know, third-party services who have access to your personal data, like health insurers and so forth, they'll probably be very sensitive to this issue, but you want to make sure that your contracts with them require them to handle the personal data in the way it needs to be handled, and you want to make sure the right indemnities are there as well. You'll also want to adjust your current practices and current human resource information system reports that are being generated. For example, you might now, you know, all companies generate all kinds of reports, and what I find is after a while, for a lot of reports, people start asking, why were we even generating this in the first place? Because that gets lost. And it's good to think about that because you might actually have, say, for example, reports going around that list all your employees and list their ages and things like that. And it's maybe not necessary, or the purpose for which it was once necessary is no longer there. And now you'd be in breach of the privacy data laws. So it's good to look at those practices and the reports that are being generated currently, and make sure that they comply with only disclosing and using personal data where the employees have been told that that's what it's used for and where it remains secured. Next, you'll want to adjust your handbook and document retention policy. I mean, the primary thing you have is the new policy for private information. But the handbook specifically should disclose uses of private data, and according to the law, should also have a procedure whereby employees can complain if they think there is a violation of the Privacy Data Act being committed. And it's good to have those kinds of grievance, if you will, procedures anyway, Because if you don't provide it as a practical matter, you're telling your employees the only recourse they have is to court. And frankly, you never want to tell any counterparty, especially an employee, that that's the only recourse they have. You want to try to have a procedure that's quite a bit less formal than that, whereby, you know, concerns about privacy or really anything can be addressed. And that's something you'll need to look at because this law is coming into effect. The retention policy will also, and I think retention policy should always be addressed periodically to make sure that they're, you know, following best practices. Because as Marion said, you should not retain the information longer than required by law or business. And I would argue that's not true just for personal data. That's true for all business records. You should look at your policies and figure how long do the requirements of law, and generally that's often tax or other regulatory driven, or the needs of the business require me to keep this information. Again, with the one exception, really the only exception of things that are on litigation hold might be kept longer than required by the business. And finally, you'll want to do due diligence to ensure that you have contractor compliance for those functions of HR and really any functions that are outsourced. Because as with any law, you can't just outsource to a third party and thereby wash your hands of compliance with this law. You're going to have to do the same due diligence the law requires you, any law requires you to do when you outsource a function. And that is, you know, do some due diligence on the contractor to make sure the contractor has practices in place that protect the private data of your employees. So if you outsource your HRIS function or some other your recruiting function or whatever it is, you just want to make sure that your contractor has in place a policy and practices that protect your employees' private data. And that's really all I had. So I want to move on to questions.
Sure. First of all, thank you, Ed and Marion. That was fantastic. We just conscious on time. We've probably got about 23 minutes. So the idea here, just for the audience, is that if you do, and we've certainly got a few questions, 5 or 7 questions now coming up. There are a couple of preemptive questions that we have from a pure HR perspective, where I will moderate and ask Marion and Ed on their perspectives on this. Thereafter, what we will do is that I'll probably call on some of the audience, some of the questions that I can already see. What we'll do is that you'll be unmuted and you'll be able to ask your question and ask it to either Ed or Marion or both for a different perspective. So what I'll do is I'll kick off first just with a few different questions. Marion, I think the first question is really for you. What I'd like to ask is that, you know, we heard from Ed from Fabrinet, for instance, is that it's mainly a B2B type business. And I think a lot of companies here in Thailand, a lot of them will be B2B and a lot of them may be of smaller scale. The question really is that if we as a company don't deal with too much customer data, should we be really worried if we've got a smaller head count and let's say it's less than 100 or 50, should we be really worried about PDPA and implementing it within our HR in itself?
So that's a very good question. And this is a question that I get a lot actually from clients, as you say, who maybe not like large conglomerates and which have a small headcount in Thailand. So worried, no, definitely not. And especially if you are a European company or an American company, because in Europe you have the GDPR, so you have to abide by the terms of the GDPR, which and the terms of the PDPA is largely inspired from the GDPR. And in the US you have the Privacy Shield, which also provides for requirements to ensure the safety and safeguard of personal data of individuals, including employees. So no, worried should not be should not be the concern, definitely.
In terms of the risk, and Ed, I'll probably relay this concern to you, is that from your experience, and you've got a large company, large headcount as well, from a HR perspective, where have you seen where, you know, some of your team, for instance, or anyone, where is the biggest risk from a PDPA perspective? I know that you've covered a lot of the different documentation, but where do you think, or where do you feel in terms of the biggest leakage areas or the biggest risk from a HR perspective?
Well, you know, again, I don't really see a risk. I mean, that the private data will not be handled properly. I mean, I don't see that, other than if someone gets the bright idea to monetize it, to start marketing the private data. I mean, otherwise, you know, it's just a question of keeping everything secure, I suppose. Yeah, I was going to almost say in the recruiting function, but no, I don't see that. I don't know.
Marion, any
I always
perspective?
think your bigger problem is with the stuff you're trying to make money off of.
That's great. Now, from a strict legal perspective, and this is actually the feedback that I will provide, of course, the main risk, but I agree with Ed, I mean, risk might be too strong, you know, to capture the implications introduced by the PDPA, but employers needs to be careful upon hiring, because this will be the period where most of the personal data will be collected. So basically, if you want to, you know, ensure compliance, just you know, be sure that you have a specific provision included in the employment contract with a specific clause whereby you really ask the employee's consent on the last page. It should be the signature of the employee on it. And if you don't have this for the existing employees, then you can, you know, just make them sign what we call a personal data collection agreement, or any other agreement, separate agreement. It will be just one page long. It's pretty straightforward, so that you ensure that, you know, I mean, you provide the information, you require the employee's consent, and yeah, and after you're good. The only, I think, requirements that employers must be aware of, is the obligation under the PDPA to have a written or electronic records of their personal data processing activities. So it's basically, it can be an Excel sheet with, you know, the type of activities that you, the type of data that you collect and process. So employee's name, ID card, I don't know, all this, and in which you would put the purpose of collection, whether, you know, the employee has provided the consent or not, or whether you intend to transfer the data, and the retention period. This is important to have this document in place. It's not a sophisticated document. I mean, even, I mean, law firms, I mean, we assist clients on that, but it can be done internally. But yeah, it should be something that employers should be aware of. And
yeah, I agree with that. And one other thing that occurs to me that might be an area of risk is transfers of private data out of the country. Especially, I mean, it didn't occur to me because we're headquartered here. So I usually have information transfer. I have the reverse issue where I have, you know, data transferred from the United States, personal data of employees in the United States or the United Kingdom transferred to me here. But that's another issue, because when you transfer it out of the jurisdiction, there's all kinds of requirements there. And the number one thing you should have is an intercompany agreement requiring your affiliate in the other jurisdiction to whom you're transferring an employee's personal data to comply with the same law and structure that's required here. Maybe Marion has more she wants to add on that, but that's one area where that trips people up.
Yes, I agree.
Just on bridging on both of what you've just said, and I know that we've just talked about the intercompany transfer of personal data. What I'd like to really ask, and I know a lot of different companies would be asking the same thing, is that PDPA in Thailand right now is relatively, it's going to be new. We have a lot of existing personal data from all of our employees right now. We have sensitive data, we have personal data. Marion, I'll go to you first, and Ed, would love to hear your thoughts on this as well. What do they need to do? So are we required to get consent from a HR perspective now for all the information that we have? Or is there some, because we have the legal basis or legal obligation to do that contractually, do we just require to disclose to our employees? So what do we need to do?
So I think we need to distinguish for what actually we don't have to, but for the data that are required for compliance with law, so PDPA is pretty clear. If it's based on a legal obligation, you don't have to obtain the employee's consent, but you always need to inform the employees and provide, the information I detailed before. So this is really important. The only difference is that you don't have to be the employee's signature on a piece of paper regarding the processing and collection of their data. But information is an absolute obligation, and you always have to, provide the information to the employee. And of course, from a legal perspective, we always advise our client to make sure that they have a proof that such information was disclosed to the employee.
Yeah, I would just add.
Yeah, no, please go ahead. I'm done.
No, that's all right. Go ahead. Well, I was just going to say, I would add that you should have a policy. I mean, a policy that's compliant with the PDPA, and communicate that policy to your existing employees and refer them to the policy. And that'll have, as I stated before, what we have in there, what we have of yours, what we use it for, and here's where you can complain about how we use it. And I think that will adequately cover where you stand on May 1st or whatever date the effective date of this law is.
Perfect. Really, Ed, this question really goes to you, and you mentioned it. I like how the fact that you said into your last slide about knowing your contractors, and also any outsourced service specifically, and usually that risk does occur when a lot of companies here would outsource payroll. So what happens in that sense of the outsourced payroll and other services? Is there, we talk about data processing agreements, and you talked about a vendor due diligence. From a practical standpoint, Ed, and then perhaps Marion, you can go ahead as well. How should we manage our outsourced vendors? What's the best way to do that?
Well, I think the best way is, like I said, do the due diligence. I mean, I'm guided kind of by like the U.S. Foreign Corrupt Practices Act. You can't have an empty due diligence file and say, I had no idea this guy was going to do that. So you have to do some diligence into making sure that this particular payroll provider follows practices that are PDPA compliant and has a policy that you can rely on. And then, I suppose you can audit it periodically, but I think if you, make your selection of a contractor based on that due diligence, you'll be fine. And beyond that point, I would say, to the extent some red flags or even yellow flags come to your attention that maybe personal data is being misused, people's salaries are appearing in the newspaper or somewhere, that you don't just turn a blind eye to that. I mean, that's just, basic, good sense in managing your contractors.
Maybe if I can add, so this question is actually very interesting, because from a strict legal perspective, when you outsource your HR services or payroll, then the person to whom you outsource becomes a data processor. Because for those who are familiar with the PDPA, there is a data controller, which in our case will be the employer, and the HR services provider company will be regarded as a data processor. And both may have a potential liability in the event of breach of the PDPA. So they have respective obligation and responsibilities, and the data controller is actually responsible to select the data processor, which can provide sufficient guarantees to ensure that data processing complies with the PDPA and to protect the right of the data subject. So indeed, as I will echo Ed's comments, it is very important as a data controller that you ensure that the data processor has a satisfactory level of data protection standards.
And just it's a really good point. And what I just took away from that is that, and from Ed, your presentation earlier, is that we do not pass on risks in terms of trying to outsource these types of services anymore. And Marion, to your point, that
no, we are not. And in the event of breach, committed by the data controller or the data processor, the employer, as a data controller, may be liable for paying compensation to the employees. So he will be primarily liable, but the employer could also face criminal penalties and administrative liability, whereas the HR service provider, as a data processor, could face civil liability. So yeah, both will be held liable, may be held liable.
Perfect, thank you. Last question before we go into other audience Q&A. And this really goes to yourself, Marion, is that, we talk about a lot of SME companies, and let's say it's a small entity. It's a one-man show type operation with around 20 or so employees. What is the expectation, do you believe, and this is probably more of an opinion, what expectation would you set? Do they need things like a DPO or a DPO committee? Should they abide and, yes?
No, but that's again a very interesting question. I smile because DPO, DPO is only required in very specific cases, meaning whether the data controller is a public authority, so it will not apply to the audience, to our clients, or whether the core business activities of the employer, of the company, involves regular and systematic monitoring of personal data on a large scale. So if you are Google, yeah, you need to have a DPO, but otherwise, if you just have 20 employees and you don't process, personal data on a regular basis, you don't have to have a DPO. Or finally, whether the core business activities of the company, of the employer, involves the processing of sensitive data. So data of regarding the gender, political opinion, religious belief, health data. So yeah, apart from these three situations, you don't have to have a DPO. It will not be required under the law.
Thank you. What we'll do is that I'm very conscious about time. We've got about 10 minutes left. I'm going to, and TK from AMCHAM, I hope you're ready to unmute a few people. There is about 11 questions. I don't think we'll get through all, so we will try to get through as many as possible, so bear with us. Jennifer did post one of the first questions. If you could unmute Jennifer, and Jennifer, please feel free to ask to the panelists.
Hi, can you hear me?
Yes.
This is Jennifer. Yes, thanks. I'd like to know if there is a breach notification period, number one, and number two, if there are, let's say, what if our employee left us due to a misconduct, right? What sort of information can we disclose to future employer?
So should I take this question, maybe?
Sure.
So in terms of breach notification period in the event of breach, so the PDPA provides 72 hours of time frame for disclosing the breach to the competent authority when there is a breach. If there is a very high risk on the individual for which the data is disclosed, the notification should be done immediately. But in general, it's 72 hours. And the second question was related to. Sorry, the second question was related
when someone leaves.
Yes, when someone leaves. Well, so that's a very good question, and I think it is important to go back to the legal provisions and the Thai law. The only obligation that you have when an employee leaves the company is to provide a certificate of employment. But any letter, recommendation letter, or any other reference to future employers are not required. So based on that, the information as to a potential misconduct committed by the employee will be regarded as a personal information, and you cannot rely on legal basis to disclose this information to another employer. So this means that if you want to disclose, any misconduct to a new employer, then you need to obtain the employee's consent.
Oh, sorry, this is Jennifer again, right? So that means if the employee left for willful for misconduct, and the future employer, let's say that is doing a background check, call us, we cannot inform the new employer, correct?
In principle, no. I mean, it depends. That's a very good.
Yeah, that is a good question. What I say is, in the U.S., we generally follow the rule, just don't say anything. And it was not by privacy laws, information particularly.
Yeah.
Yeah.
So we would never, you have nothing good to say about someone, don't say anything. So you generally put in a policy of just saying, yeah, the person worked here from X day to X day as in this position. And that's really it. Now, it would be more interesting, I don't know, beyond the scope of this, to say, well, what if the person was fired for bringing a gun into the office? And, and then they should, something like that, where there might be an independent duty to warn if you'd want to get legal counsel and see if you should disclose that. But barring some extreme circumstance like that, I generally follow the rule. I wouldn't say anything more than, as Marion says, that the person worked here from here this day to this day, and what their last position was.
Okay, got it. Thanks.
And it's worth mentioning, and thank you, Edward, for raising that. The concept of defamation in Thailand is very, very powerful. It's a very strong concept. So my recommendation will be to not answer.
Okay, thank you.
You have nothing nice to say, don't say it at all. Okay, let's go on to the next question. Still a few more minutes, so we'll try to get through another 3. I apologize if I'm saying the name incorrectly. Debometer. Is that correct? TK, if you can help me, and from Colgate. I take the silence as potentially cannot find or already left. Let's go on to the next one. Peter from ISM Technology. If you could unmute Peter for us, please.
Okay, yeah, hi. Can you hear me now?
Got you. Thanks,
Great.
Peter.
Okay. This is sort of a corollary to the other question about third-party disclosures. If you're disclosing an employee's personally identifiable information to a third party, as might be required for the company's performance of contractual obligations to a client, let's say you're seconding an employee to go work at a client, and in the context of that, you have to disclose certain PII. Could be a resume, could be whatever. What can the company, the employer, reasonably require from that client in the way of the client attesting to its own compliance with PDPA? Presumably the employer has some obligation to its employee to ensure such compliance by that third party, by that client, when disclosing the employee's PII. Even if you're doing it for performance of a contract, there would presumably still be that obligation. What can we reasonably expect to get or to require from the client to prove that they have equivalent compliance?
Ed, you want to take
Edward,
that?
maybe Edward, do you want to address that?
Yeah.
Well, I'm not sure I've really followed. Say if you second an employee to a, say, customer.
Yes, to a customer in the context of complying with a contract for that customer, they may reasonably expect, and maybe requirement really of the nature of the contract, that you disclose PII of your employee. So in doing that, I would guess that the company has an obligation to say, hey, client, do you comply with PDPA? Can you show us your policy? Or what can we reasonably expect would be, what we can ask for, and what the employee actually has a right to expect that we ask for in disclosing their PII under that context.
Well, I think if you're seconding an employee, you certainly have a right to expect that secondment will comply with the law. I mean, I would first of all get the employee's consent to give the PD to the new company, but I would also be guided by the, like say, the third party contractor principle of doing some due diligence into making sure your counterparty to whom you're effectively loaning your employees to, that they comply with, really not just the PDPA, but perhaps other labor laws as well.
But maybe your question is,
other than that, I just you get an indemnity in your contract with them.
Well, yeah, okay, but I mean, it's specific to the PII in this case that they should be able to demonstrate that they have a policy and they are attesting to their compliance with this data they're receiving from you about your employee.
Right. And you would certainly want to see their policy at minimum.
Right.
Yeah, policy or written covenant, by which the client, the contractor client, accept and testifies that they abide by the rule of the PDPA at minimum.
And that would include retention and all of that other stuff. You'd want to see how they deal with that. Yeah. Okay.
Thanks, Peter. Look, we are right on 3 p.m. I'm going to ask one last question. Just in terms of saving time, I'm going to lump this together so we won't unmute. So I'm trying to lump two questions at once. The question is really around, Siam Premier did ask a question. If the company uses photos that contains photos of employees for marketing purposes for CSR, that's really the question. And I'm going to lump that with another question talking about social media. The use of employee photos for social media. We see it a lot on LinkedIn, on Facebook for our company, where we have these, photos of our employees on there. How does PDPA, and what is the impact on PDPA on doing this? Do we require consent in doing that, or is that covered in the overall HR policy that Ed and Marion, you did mention as well? How do we deal with social media and the photos that we have from our employees?
Social media is a very good example. Definitely, this will not fall into the purview of legal compliance because, nothing in the law asks you, to take photos of your employees. So the only lawful basis on which you could base, the collection of photo, and if you want to disclose and, disclose these photos, is then it is absolutely necessary to have the consent of your employee. But again, it can be 1 page long, and if it's 1 or 2 page long, if it's sufficiently drafted, it shouldn't be an issue.
I have actually a practical answer. I agree with that. Your practical answer to it too is, first of all, most people whose photo ends up on either the CSR or some other part of the web page is usually flattered by it rather than feeling harmed by it, which is an interesting psychological phenomenon. In other words, most people don't complain about that. They say, hey, my picture's on the website. They don't say, hey, my picture's on the website, how dare you? But the other thing I would say is that I don't think the PDPA, I guess the PDPA adds another layer of protection, but prior to the PDPA, like right now, you're not really at liberty to use the image of your employees for your marketing or your web page or social media anyway. Again, as I said at the beginning, of my presentation, that's what the PDPA is really all about, is controlling the use of all this data, especially in terms of monetizing it. That's what I meant before I say, but don't use any of your HR data for monetization purposes. And I would include in that, your own marketing, unless you have the express written consent of the employee. I just put out there that, most people don't complain when you put their picture on the website because, you know, presumably if you're putting a picture of an employee on a website, it's a good picture.
Mm.
But you're right, it could happen. It could be complained about, and technically, if you didn't have the agreement, the consent, PDPA.
And especially if the employee leaves the company, especially.
Yeah.
Because
Yes.
we know that it can take sometimes, you know, from the departure of the employee and the time we update the website. So the agreement should take that into consideration.
Right. Good question.
Thank you. What we're going to do, I do apologize that we didn't get through all questions. We are on limited time and we're trying to keep on time. AMCHAM, Nico, could you please put up the last slide for me, just so I can talk through the upcoming events. First of all, I'd like to say, before I go on to this, I'd like to say thank you so much, Ed and Marion, for spending the time talking to us today. We have tried to focus this event more on the human resource aspect of it. I think a couple of the key takeaway points is make sure you have your HR privacy policies in place. Make sure you update your employee handbooks. Make sure you identify the PII, the personal information that you currently have of your employees. Understand what is personal, understand what is sensitive, certainly understand the legal basis of collecting that data. Where you have a lot of existing data right now, I think, as per Marion and Ed, make sure the policy covers it. Make sure that you disclose at least. So just because you have the right to have it and there is a legal or contractual basis, you still need to explicitly disclose to them that you have this information and for what purposes. Where you don't necessarily, and for sensitive data for sure, make sure you obtain the right consent in doing that. As a company in itself, make sure you have all of those data subject rights in place, making sure that they have a complaints process internally. They can erase, they can change the data to make it current. Make sure you have all of these components in place. For international transfers, make sure that you have the right rules and obligations in doing that as well, whether it be binding corporate rules, whether it be data transfer agreements. Last point as well, as both of them did mention, is that make sure that if you are using third-party vendors, that they have the right policies and processes in place, whether you're seconding them to a client, which is a little bit more complex, or you're outsourcing payroll. Vendor due diligence is absolutely key because they aren't going to be the only ones that are going to be liable. You as a company, as a controller, will certainly be liable at that as well. So make sure vendor due diligence and data processing agreements are in place as well. Just to wrap up, in terms of the upcoming events, there are just a few. We've got a busy month ahead. In terms of the Trade Investment Committee, there will be a webinar on what's next for investment in Thailand. That will be, we will have a special guest, Secretary General, Thailand Board of Investment will be there for us. So February 24th at 2 p.m. Our next one will be with the AMCHAM virtual membership meeting. So that will be on the 1st of March at 2:30. And our Honourable Minister for Finance will be there as well. In terms of our PDPA type series, and over the next few months, there will be a lot of these. This was focused on HR. In terms of our Digital Economy Committee, they are very much focused more on the digital side of things, which is part of it, not all of it, but they're focused more on the implementation around obtaining consent and collection of personally identifiable information. That will be a webinar as well. Group CEO from Bluebig Group will be there March 9th at 10 a.m. Finally, from the HR committee, our next is going to be on employee wellness. We'll be giving you a different perspective from the health perspective and from a company perspective as well, as to what do you do during the pandemic? How do we take care of our mental and physical wellness throughout? Also be a webinar on March the 18th at 9 a.m. Apart from that, again, I would like to thank AMCHAM, everyone for helping, and also certainly Ed and Marion. Very much appreciate that, and thank you all of the attendees for joining. We will hopefully be face-to-face in the next few months, but up until then, we'll see you virtually online. Thanks again. please keep up. The recording will be on AMCHAM website, as will be the slides. Thank you. Have a good afternoon. Bye-bye.
Thank you so much, Sean.
Bye.